So I was about to turn to the question to Mr. Pilbara whether his case was that Lord Kerr and Lord Sumption were wrong.
Yeah.
Now, yesterday, of course, the only answer that my friend Mr. Pilbara could give to that, he couldn't in substance bring himself to say that they were wrong. So what he said is, well, they say the correct analysis is in the Khaimah decision. Khaimah decision is an analysis of particular facts. He may say an analogy, I say no analogy at all, and I'll get to that.
Yeah.
But it's not setting out, as it were, the general principles. And then this morning, he was driven to return to that question. And he said, well, he has two reasons not to accept Lord Sumption plus 3 in the Supreme Court. And the first was, he said, well, it shouldn't be a bright line. In a case where the issue was raised in the first trial and there was a decision not to investigate, was his first qualification. It's an interesting qualification because, in fact, Lord Sumption makes exactly that point, in paragraph 66 of Dechert. So it's a poor criticism. But more importantly, for present purposes...
It's in there anyway, isn't it?
It's in there anyway. So more importantly, for present purposes, that's not this case. It's not that Mr Azima decided not to investigate RAKIA's concealment of all of this. It's that RAKIA dishonestly concealed it. His second point was, well, that doesn't really help you if the lower court, the first court, the Court of Appeal for this purpose, has said in effect, whatever comes, regardless, you can never reopen forever and a day, which is obviously right, not a point that Lord Sumption was considering, though the surprising nature of that point, it does make one sort of reflect whether the court could ever have intended to mean. So not a very persuasive attack on Lord Sumption. And then, rather graciously, he said that he would accept Lord Kerr's speech if it was phrased differently. Someone must remember to tell him. And that instead of the word discretion, it used the phrase just as justice may require. Well, whatever one does with any of that, again, no answer to this case. So really, where this case gets back to is that the position, collectively, Lord Kerr and Lord Sumption, is a correct analysis of the law. It's important then to emphasize what some of the judgments have said about the situation in which a judgment has been procured by fraud. And one place to pick that up is in Dechert itself. So if I can ask you to look in the authorities bundle, that's MAAB tab 10, again, and just pick up a few of the dicta that emerge from, in particular, the analysis in Lord Kerr's speech. Starts, of course, paragraph 43 on page, that's bundle page 13 of tab 10, with HIH casualty and general insurance versus Chase Manhattan about fraud being a thing apart. Fraud unravels or vitiates all transactions whatsoever, and explains why. Then paragraph 44 moves on to the Amptill peerage. And you'll recall that when Mr Pilbara dealt with the law, he took you to the decision in Allsop, which is also in the authorities bundle. But he did so in order to get the quote from the Amptill peerage. But the quote in the Amptill peerage is here too, then set out. And if you turn over the page, what he cited was the first part, that the law recognises that judicial determination may be imperfect. It aims at providing the best and safest solution, and it then closes the book in the interests of peace, certainty, and security. It prevents further inquiry. And rather charmingly, he said, well, he could read on, but it wasn't necessary. But it is actually necessary. So we should read on. So it continues. There are cases where certainty prevails over the possibility of truth. And there are cases where the law insists on finality. For a policy of closure to be compatible with justice, it must be attended with safeguards. And so the law allows appeals. And so the law, exceptionally, allows appeals out of time. And so the law, still more exceptionally, allows judgments to be attacked on the grounds of fraud. So the set-aside claim is an exercise of the qualification, the safeguard, identified in the Amtil Peerage by Lord Wilberforce against an excessive application of the principle of finality. Paragraph 45, Lord Kerr then cites from Lord Buckmaster's decision in Hip Fung Hong versus Neotia. In all applications for a new trial, the fundamental ground must be that there has been a miscarriage of justice. You have to show fraud, to establish the fraud condition. But then at the end, a judgment that is tainted and is affected by fraudulent conduct is tainted throughout, and the whole must fail. And that's a good example of what one finds in repeated judgments, which is that fraudulently procuring a judgment is a very serious thing, and it is a thing which, bar exceptional cases such as the Koshy case and principles of election and the like, it is something which the court will generally take up by setting aside the judgment. Not, of course, deciding the merits the other way. Set aside the judgment and tell the judgment creditor to come with honest evidence and do the job properly and see whether the case can be sustained. Further, paragraph 48. Lord Kerr dealt with the Australian and Canadian decisions. He did so because in both of those jurisdictions, the courts had already found that the reasonable diligence requirement should not apply in cases of fraud. And so started, in regard to the High Court of Australia, with MacDonald versus MacDonald, and dealt with it at some length, but if we can pick it up on the next page, the last part of paragraph 48, citing Justice Menzies in that case at page 542, discussed the grounds on which a new trial can be ordered on the basis of fresh evidence and then observed. This leaves untouched the rule that if by any means it be proved affirmatively that the earlier judgment was tainted by fraud, it will, without more, be set aside. Similarly, as to the Canadian decisions, paragraph 51 on the next page, Canada versus Granitile Incorporated. Last part of the paragraph, where fraud is present, finality will give way to the responsibility of the court to protect its process so as to ensure that litigants do not profit from their improper conduct. And then an endorsement of Lord Justice Newey's decision in the court below in Takar that found the finding that the reasoning in the Australian and Canadian cases was compelling. And then paragraph 53, wrapping all of that up, I agree with all of that. It appears to me that the policy arguments for permitting a litigant to apply to have a judgment set aside where it can be shown it had been obtained by fraud are overwhelming. So my own friend Mr Pilbrow sought to say, well, there are two issues here. There's the fraud issue and there's the finality issue, and they really are of equal and important weight. And this is a case in which finality should triumph. Now, finality obviously is one of the criteria, one of the questions, one of the principles at play, as Johnson and Gorwood makes plain. But what these dicta show, and the analysis of the Supreme Court of Lord Kerr and the Supreme Court shows, is one does need to put it in its proper context, and it very much can be said that once you show fraud, finality rather takes something more of the back seat. Can I also give you a reference to a case that is not in the bundle but was cited below? It is in an earlier bundle, so I'll ask the operator to bring it up on the screen. If the operator could go to October Authorities Bundle, tab 21, please. It's the case, my lords, of Seleki-Poor versus Palmer, in which, my lord, the Chancellor was a concurring member.
Yeah, I remember this case, yes.
And I'm not going to go all the way through it, but you'll see on the head note, dealt with the Hamilton Al-Fayed decision. This is an attack on a district judge's decision to strike out as an abusive process they claimed a position on grounds of perjury and subornation of a witness for an order of a new trial. It largely concerns the jurisdiction of the county court and whether the county court can strike things out for abusive process, which is all very interesting, ultimately concludes that it does have that jurisdiction. But then you see per curiam, what is said in the head note. And can I ask you please to go down to page 20. Paragraph 95. The suborning of a witness by a party to give perjured evidence in order to succeed at trial is a most serious matter, which not only taints the evidence of the witness, but potentially undermines the credibility of the party on all issues. That certainly is the case, where so much turned on credibility. If the fact of subornation and perjury as described in Mr. Fitz's witness statement had been known to Judge Marshall, QC, it is highly likely that it would have had a material impact on her assessment of the credibility of the evidence given by Mr. and Mrs. Palmer, who had been found not to be credible, relying on the other evidence. And one may just immediately carry that into this case. That is this case, top to bottom. Mr. Azima and Mr. Adams ultimately found not to be credible, and their explanation of the documents that worry the Chancellor is rejected on credibility grounds. And that credibility evaluation takes place in the prison in which Mr. Buchanan and the ruler and Mr. Gerrard have all also given evidence and have been found by the deputy judge to be essentially credible. Only small points of criticism, if you like. Indeed, one of the points is the statement in the judgment that one can have some reliance on the fact that Mr. Gerrard, as a solicitor, said various things. And yet what is now known is those three people were lying through their teeth from the beginning to the end, and that Mr. Gerrard was conducting a perjury school, and that Mr. Buchanan was insisting that the whole approach to the settlement and to the claims against, the facts underlying the claims against Mr. Azima should be seen in circumstances in which they knew nothing, they had not investigated, they had no knowledge of what the facts behind the scenes were, they had never heard of the referral agreement, etc., etc. Just lying from start to finish. So I do commend to you paragraphs 95 and indeed 96 of the judgment of the Master of Rolls in Seleki-Poor. And similarly, can I just make a point about Highland, which is in tab 7 of the Authorities Bible. You've been taken, this is RBS and Highland, the judgment of Lord Justice Aikens. You've been taken to paragraph 106, which is the paragraph in which he sets out what the test set aside for fraud is. And I don't have to repeat all of that. But then paragraph 141, if I may. What was argued in that case? I've just explained it perhaps. Summary judgment was granted. And there was then a hearing of some quantum issues, which various evidence was given. And then later, the application is brought to have the judgment set aside for fraud. That is to have the summary judgment set aside for fraud. And the argument by the judgment creditor is that the evidence led in the quantification stage of the proceeding, so afterwards, the evidence led afterwards, sufficiently establishes that the same result as was achieved by summary judgment would have been achieved by an analysis of the merits. And well, Justice Akins deals with that in paragraph 141. I cannot accept that argument. In my view, it is necessary to concentrate on the only judgment that is said to be impeachable by a fraud of RBS, that is the liability judgment. And then I won't read the whole paragraph to you, but all the way down to the last sentence, it would be unjust now to permit RBS to have the fruits of the quantum judgment, even though obtained on the full facts, if it would not have had that advantage, if the full facts had been revealed when they should have been revealed. Now, stand back for a moment and consider this case. What learned friends want to say is, this fraud committed by RAKIA and Mr Buchannan and Mr Gerrard, this fraud really would have made no difference. If they'd done it honestly, the documents would have been disclosed and the court would have come to the same result, nothing to see here. And as Lord Justice Akins explains, that is simply the wrong analysis. The right analysis is, was the approach and reasoning of the deputy judge subject to or influenced by the fraud in an operative cause sense, not the operative cause, not the right result, but an operative cause. Was his approach, was the fraud an operative cause of his approach? And we say, well, plainly it was. And that's the only question. Now, can I then...
I mean, paragraph 141 is picking up on the point he made, his third point in paragraph 106.
Yes, that's correct.
And I think in subsequent cases the discussion is the second point, his second point, and the judge discusses this a bit. I don't think it matters for present purposes, but whatever else was meant by material, it didn't mean that you had to demonstrate.
Exactly.
That the decision would undoubtedly have been different. What you had to demonstrate was that it would have had a material impact on the judge, on the decision of the judge in the first case.
Yes, with respect, that's right. So
what you don't do is to take the new evidence, add it to the old evidence, and ask yourself the question:
what's the right answer?
Would I reach the same conclusion?
No, that is absolutely.
And a fortiori, at this stage, where what one's dealing with is an application to
for permission.
For permission to run the point.
Quite exactly so. Exactly so. So that point about paragraph 136, about 106, it expresses these 3 points. Subsequent cases have said they're essentially two: the fraud condition and the materiality condition. And the third is a gloss on materiality. And that, yes, it absolutely drives through to this in the context, in this case, in which the very argument was, but it made no difference in the end. Can I turn then to a third point, which is the point that I briefly alluded to earlier, related to Phage and Chobani. One of my juniors said to me it might be Farher and Chobani. I confess not to know, but I will call it Phage.
Is it in the bundle?
It's not in the bundle. It is dealt with by the Court of Appeal in the Court of Appeal judgment. So that supplementary bundle of tab, either 11 or 12, I beg your pardon. 11. And if you turn to paragraph 66, so supplementary bundle, tab 11, paragraph 66, appeals on fact, and then sets out the principles starting with the decision of this court in 2014 in Phage and Chobani, saying that those observations have been approved and applied many times. And that is that an appeal court should not overturn findings of fact, including inferences drawn from findings of primary fact, unless compelled to do so. So what the court then identifies is that it's well established appeals to this court have to demonstrate an error of law, or they have to demonstrate a failure of approach. The trial judge approached the matter in fundamentally the wrong way. What this court does not allow is for litigants to come and say, well, you should reach a different conclusion factually on the same material. And Mill and Friend sought to persuade you that this case should be seen as one with an unimpeachable liability on Mr Azima's part lying behind it. And he and Mr Pilbrow, I beg your pardon, not Mr Pilbrow, Mr White, sought to make something. Mr White indeed said it was a very critical point this morning. Sought to make something of the fact that, pressed by the Court of Appeal, Mr Lord, in the first appeal, had to accept that there was no challenge in the to the primary findings in regard to the misrepresentations and the conspiracy and so on. But all of that is because you cannot appeal on grounds like that. And one must just reflect then on the nature of the jurisdiction to have a judgment set aside for fraud. And in my submission, it is the very opposite. To the point about showing fraud and then persuading the court to set aside the judgment is almost entirely to do a completely fact-focused thing. Easiest example is obviously the perjurious witness, the witness who comes and gives perjured testimony. If you raised in an ordinary appeal the credibility finding on RAKIA's main witness should have been a different one, the Court of Appeal will simply not entertain that argument, deferring to the trial judge because of the trial judge's role as the primary trier of fact, and indeed in the case of credibility, because of the trial judge having seen the witnesses live and had all of the advantage of having the evidence unfold in front of them. It does not follow, so you couldn't appeal on that, it does not follow that when you seek to set aside the judgment for fraud, demonstrating the perjury of those witnesses, that it should then be said, well, you didn't challenge those findings of the trial court, and therefore there is at the heart of this an unchallenged or unimpeachable case as to liability. It's just a completely false analysis. And once one sees that, all of the points that are made, frankly, about the arguments in the Court of Appeal just have to be put into a different spotlight. The appeal was constrained by the usual rules of this court. Once fraud is established, those shackles are removed, and they are rightly removed. Indeed, it would be a fundamental denial of the right of access to justice if it were to be said, you can't appeal on a question of fact, and when you later establish that that fact was operatively caused by fraudulent evidence, that it would be said, no, but you didn't challenge it on appeal. That's just not how it works. That takes me to abuse of process. I'll be quite quick, I think, on abuse of process. Johnson versus Gorewood has been referred to many times. Can I just pick up one point in that, 2 points in that judgment? So that's in Authorities Bundle tab 4. And I'd like you to turn, if you wouldn't mind, to page 31 first. This is after explaining the nature of Henderson and Henderson abusive process and its distinction from cause of action, estoppel, but also that the underlying interest is the same, finality, and that a party should not be vexed twice in the same matter. That's at letter A. Those are the passages you've been referred to already. And then at the letter C, there will rarely be a finding of abuse unless the later proceeding involves what the court regards as an unjust harassment of a party. So,
Sorry, I haven't got there.
yes, I'm sorry. So we had dealt with next to the letter A, and
Yeah.
then towards the end of the part following the letter B, Lord Bingham says, I would not accept that it's necessary before abuse may be found to identify any additional elements such as collateral attack on a previous decision or some dishonesty. But where those elements are present, the later proceedings will be much more obviously abusive. And then continues, and there will rarely be a finding of abuse unless the later proceedings involves what the court regards as unjust harassment of a party. So when my learned friend Mr Pilbrow said one should give effectively equal weight to the finality point and the twice vexed point, that's not a fair reading of Johnson and Gorwood itself. They are both factors, but where you don't have the twice vexed problem, it needs to be a particularly strong case. Not impossible, but a particularly strong case. And turning back to page 29 of that judgment,
Well, it's a point that's really picked up by Sir Andrew Morris in Bairstow.
I'm coming to Bairstow, and I agree.
It's the same point, isn't it?
It is exactly. It is exactly. And it has been, if I may say so, then cited by your lordship in some subsequent decisions.
Yeah, I've cited it more than once, but I can't now remember in which cases.
I'll refer to a couple of them. One of them is Pricewaterhouse and BTI.
Oh, yes.
Yes. And it in turn refers back to an earlier one. Just at page 29 of this decision, you'll see if you're looking at starting perhaps page 28 at the top, there is consideration of a judgment called Manson versus Furcht.
So we're still in Johnson and Gorwood, are we?
In Johnson Gorwood at page 28. Yeah, and that goes on for some distance, as it were. I wanted to pick up the quote that is then given at the top of page 29. It is, of course, axiomatic that the court will only strike out a claim as being an abuse after most careful consideration. But the court has to balance the plaintiff's right to bring before the court genuine and legitimate claims with the defendant's right to be protected from being harassed by multiple proceedings where one should have sufficed. So this concept of balance, again, we would say, reflecting the importance of it being a situation in which the same party is being vexed twice. My friend Mr Pilbrow took you to the Michael Wilson decision. That's Michael Wilson versus Sinclair. It's Authorities Bundle tab 8. And he reviewed the law from paragraph, he reviewed the passages in that judgment in which Lord Justice Simon reviewed the law, starting from paragraph 41, it may even have been 39, Hunter and Chief Constable of West Midlands Police, then 41, Arthur and Simon. And he ultimately then took you through to paragraph 45, which is Secretary of State for Trade and Industry versus Bairstow. And I'm going to come back to that in a moment. But he then took you to paragraph 48, page 12, and said to you that, well, for his purposes, he need only read you subparagraph 1, which is that the power to strike out a claim for abuse of process is founded on two interests: the private interests of a party not to be vexed twice for the same reason, and the public interest of the state in not having issues repeatedly litigated. See Hunter's case and Arthur Hall and so on. And said you need not refer to any of the others. This summary in Michael Michael Wilson and Sinclair has been cited a number of times subsequently. I would commend the whole of it to you. But can I just pick up subparagraph 5 on page 13? It will be a rare case where the litigation of an issue which has not previously been decided between the same parties or their privies will amount to an abuse of process. See Lord Hobhouse in re Norris. Again, same emphasis. Now, my Lord the Chancellor's judgment was in PricewaterhouseCoopers versus BTI, and I'll just give you the citation. It's not in the bundle. It's 2021 EWCA civil case, page 9, and the relevant analysis is at paragraphs 82 to 86, emphasizing both this paragraph and the decision in Bairstow and Secretary of State. And in paragraph 86, your Lordship emphasized that if it's not the same parties, it will only be in a very rare or exceptional case that the court would find abuse of process. And turning back to Secretary of State for Trade and Industry, which is quoted in Michael Wilson at paragraph 45, again exactly that point, which is that if it's not the same parties, it really comes down to whether it would, the Roman 1 and Roman 2 at the end of the paragraph, it would be manifestly unfair to a party to the later proceedings that the same issues should be relitigated, or 2, to permit such relitigation would bring the administration of justice into disrepute.
Well, that's the point that I raised yesterday.
Exactly, you did.
Mr. Pilbrow, I think it's Mr. Pilbrow, that applying that principle here, obviously if the case that you were seeking to bring now was within, as it were, the prohibition of the original Court of Appeal judgment, then that would be an example of permitting relitigation would bring the administration of justice into disrepute, because you can go behind the Court of Appeal judgment.
On that premise, I accept
to what does the Court of Appeal judgment really mean?
Exactly.
But if you're not, then you don't fall within this exception at all.
Yes, with respect, that's entirely right. So if, as we say, that's not what the Court of Appeal intended to do, and we'll go through the judgment in due course, then, au contraire, this is a situation in which really abuse of process is not appropriately applied. The final point on that is just, so what you find in the judgments is the express qualification that striking out for abuse of process, preventing something proceeding on abuse of process grounds, is something which may be motivated on appropriate facts, it may be justified on appropriate facts, but it is subject to close scrutiny and not easily applied. And if the party is not twice vexed, it would have to be truly exceptional. And then on top of that, one should layer the fact that in the context of claims to set aside a judgment on the ground that it was procured by fraud, really there is an additional qualification. And one sees that in paragraph 66 and 67 of Lord Sumption in Takar. So if decisive new evidence is deployed to establish the fraud, an action to set aside the judgment will lie, irrespective, and then the qualifications. And frivolous litigation, the danger that the finality principle will be eroded by everybody trying to re-argue their appeals on the basis that the underlying judgment was obtained by fraud, is adequately prevented, that's paragraph 67, by the Highland factors, which have been found to be satisfied in this case. Can I pick up my learned friend's emphasis, my learned friend Mr. Pilbrow's emphasis, of the decisive, the word decisive in paragraph 66 of Takar, which he says, and I confess I haven't checked, that we omitted in a quote in my skeleton, and if we did, that would be my fault, and I would apologise for it, because it would certainly be wrong if it was a quote. But the point about decisive is that decisive is what is dealt with by the requirement of materiality. And that's quite clear on reading Lord Suchn's speech. So much for the law, save for Koshi. Can I now turn to, I want to look at the new evidence, but I want to look at it in the light of what was the case before, what's the case now. And so can I start with a series of points about the first trial? In the course of these points, I'm going to give you some references to the judgment of the in the trial of Deputy Judge Lennon. That is at supplementary bundle tab 1. But in the interest of time, I'm not going to turn up each one. What I'd like to do is explain what the contrast is. So, first point. I will turn to one or two of them. But first point. In the first trial, RAKIA's case was that Mr. Halabi and Mr. Page had innocently found the BitTorrents containing the hacked data on the internet in August 2016. And they have continued thereafter to maintain that case until the point at which they fled the jurisdiction. Their only fallback position, and one sees this in the arguments before the Court of Appeal, is that, well, even if Mr. Page was dishonest, his explanation not having been accepted by Deputy Judge Lennon. Certainly RAKIA and Mr. Buchanan were innocent and knew nothing about that hacking. That was their case. And that is variously, one can see it in paragraphs 2, 52, 251, 258, 342 and following, and 356. That's the first point. Secondly, in the trial, RAKIA disclosed only a heavily redacted version of the first Project Beach report, insisting that all others had been routinely destroyed for security reasons. That's paragraph 266, paragraph 275. Thirdly, RAKIA disclosed, it did not disclose any other project updates, but it also did not disclose any invoices or other documents relating to the work performed by Mr. Page or those who Mr. Page had contracted. Fourthly, RAKIA's case, as expressed in the witness statements in the trial, concealed the source of the fact that the source of the project update report was Mr. Page. And that only emerged in the course of cross-examination and from recollection when Mr. Buchanan gave evidence. I think him saying he'd drawn it to the attention of his lawyers, but a decision had been taken not to reveal it, if I remember correctly. And you'll see that paragraphs 272 to 278. And I would, in that context, just pick up paragraph 276. So in SB1, paragraph 276, which is on page 90, MASB, tab 1, page 90. This coming to the end of the judge recognizing that there is some criticism, or there was some criticism to be advanced against RAKIA for not having dealt with Mr. Page's role in regard to the updates in its witness statements. But then see the second half of the paragraph. I recognize nevertheless that the failure to deal more fully with the project update may simply be explained on the basis that it was an unhelpful document that was not referred to in Mr. Azima's statements of case, rather than on the basis that it was part of a plot to put forward a false case about RAKIA's role in the hacking. I do accept it's surprising that if there had been such a plot, that the project update was disclosed. That's because Mr. Tomlinson argued, if we were trying to hide this, we'd not have disclosed it at all. And this was all grist to the mill. So really, RAKIA can't be such bad chaps. They wouldn't have done it in those circumstances. Well, of course, we now know a completely different position. Continuing with the trial, both at the trial and all the way through to the case management conference in March last year, in dealing with the list of issues for disclosure, it has been RAKIA's case that it did not procure the investigation of Mr Azima at all, despite the reference in the March 2015 project update. It said nothing was done about that. It's never investigated Mr Azima, and it may have investigated Dr Massad, but it absolutely did not do anything unlawful or illicit in obtaining information by hacking, even in regard to Dr Massad. Not only that, that was bolstered by a denial that Mr Azima was included in the class of associates of Dr Massad who may have been investigated. That's a judgment paragraph 268. There was evidence in the trial of two communications. One in April 2015, in which the ruler had asked Mr Buchannan to target Mr Azima, and one in July 2015, in which the ruler had given an instruction to Mr Bustami to go after Mr Azima. And the RAKIA's case was that nothing was ever done in response to those instructions from the ruler. They were discussed and nothing was taken forward. It was dismissed as an entirely empty proposition. And you'll see that in judgment 289 and 291. Next point. RAKIA repeatedly insisted throughout the trial, and this is in Mr Buchanan's evidence in particular, that it had known nothing of the matters alleged against Mr Azima on the good faith misrepresentation case, which includes the heavy lift misrepresentation but goes quite a lot further, that he had known absolutely none of that prior to the discovery of the material on the internet in August 2016. And if you want to see those passages, we've put not a complete set of them, but a whole range of them into Schedule 1 to the re-amended counterclaim.
Yeah.
And one reads this evidence of Mr Buchanan and then has to consider what his credibility is now. Then there's the view from the window document, which my own friend Mr Macefield dealt with. It's dealt with in the judgment, paragraph 304 to 309. And this was a document from Mr Frank, which appeared to show knowledge of misconduct by Mr Azima, and therefore was relied upon by Mr Azima as demonstrating that there must have been access to hacked materials. And again, Mr Tomlinson sweet-talked his way around that, about how vague it was and improbable it was, and so on. And ultimately, the judge accepts that it is not a sufficient indication that they are in possession of hacked information. We now know they are in possession of hacked information from July, August 2015. Judgment 316 is an example, it's only one example of suggesting that there was no, it's actually dealing with Mr Page, but that there was no information known about heavy lifting. No, that's not true. Judgment 378. Very big point that RAKIA advanced was they contended it was wholly improbable. And my little friend Mr Macefield dealt with this point too. It was wholly improbable that RAKIA would have settled in March 2016 if it already had the information later discovered. And advanced, Mr Tomlinson advanced a whole series of improbabilities about that. Paragraph 378 of the judgment ultimately accepted. We now know that they did have their hacked material, had it for 6 months, and it did show all of those things. Again, in the first trial, come to the conspiracy, RAKIA disclosed no documents at all about the 2011 hotel transaction, save for those obtained from the hacked material itself. And this is judgment paragraph 171 to 174. And if you have regard to paragraph 173, you'll see indeed in RAKIA's submissions, it positively relied on the absence of document, saying, well, if there had been a referral agreement, etc., well, then they would have had the document. The fact that they don't have was treated as a point in their favour rather than a point against them. Again, we now know they did have the documents. Judgment paragraph 180 attacked the referral agreement as a sham, and the ruler denied any knowledge of the fact that Mr Azima was receiving a commission, effectively saying he knew nothing about the referral agreement at all. And that's ultimately accepted. We now know they had the referral agreement. So that's entirely unsustainable. Lastly, contended that Mr Azima's interest in the hotel transaction, the 10% interest, had never been disclosed and that the ruler had not known about it, contrary to Mr Azima's case. This is judgment paragraph 190 and 195. We now know, of course, that actually that was known from an early stage, revealed in the project update reports, as I will show you. So it is true that Deputy Judge Lennon rejected the adequacy of the innocent discovery explanation, not believing Mr Page and Mr Halal. But RAKIA has never identified a new version. All it has done is retreated behind the proposition that, well, so far as it is concerned, it was entirely innocent. And that's through several applications to admit further evidence, the appeal, objecting to the application for permission to appeal to the Supreme Court. RAKIA never wavered from that stance. And one can actually see that in the Court of Appeals judgment in paragraph 134. So we really just are in completely different territory. So it's of some importance to note. RAKIA maintained that position until it fled the jurisdiction. Mr Buchanan, on his pleadings, continues to maintain that he knew nothing about the hacking and that he did positively rely on the alleged misrepresentations, etc., despite the fact that the updates, which I will show, record critical work being done on his instructions, and despite his acceptance at the trial that essentially all of the update reports were delivered to him. He was their initial recipient. Mr Gerrard continues to maintain that he was not party to the hacking and that he knew nothing of Mr Azima's information at the time the settlement agreement was being negotiated, despite the compelling evidence that he was a party to a number of the update reports, some delivered to Dechert's offices in London, some to his home, and that he contrived the innocent discovery story. That's Mr Page's evidence, is this was all contrived by Mr Gerrard, initially in collaboration with Mr Buchanan, and then without Mr Buchanan conducting the perjury school at the hotel. Now both of them in their pleadings now claim to be dyslexic and say that they intend to run a case that they have difficulty processing documents. Well, the fact that Mr Buchanan was dyslexic, I think, was known in the first trial, but it's not a point that was made to rely on, so far as I'm aware, in regard to knowledge of the project updates. He denied that they did any of this nefarious stuff at all. And so far as Mr Gerrard is concerned, it's true he was only diagnosed with dyslexia in 2021. But as the judgment in fact recalls, he gave very bombastic evidence, insisting no wrongdoing, no wrongdoing. And that reliance now on dyslexia may be viewed with not a little scepticism in our submission. Dechert, of course, have now had to part ways with Mr Gerrard after the two judgments of His Lordship Mr Justice Waxman in EMRC and the Serious Fraud Office, the second being the costs judgment. But they just retreat to saying, well, we didn't see anything, we don't know anything, we don't admit anything. Really not very helpful at all. So, that by way of side notes to that analysis. Now, for purposes of the 2021 Court of Appeal hearing, first appeal, Mr Azima did bring some new evidence. That's true. Important to know what he brought. He brought the phishing emails that he couldn't attribute to anybody. And then he brought the witness statement from Mr. Ray to say that Indian hackers admit, from Cyberroot, a hacking organization, admit to having done this, and Cyberroot having been engaged by Mr. Nicholas Del Rosso. The Court of Appeal make the point. That was a new version, and my learned friend Mr. White sought to point out and rely on the fact that it had different timing, which was problematic for part of Mr. Azima's case. But that's the evidence that he had, and then the Nairobi witness statement in regard to the introduction. The new evidence that has subsequently become available just goes a country mile further than that. And it's summarised in paragraph 78 to 84 of His Lordship Mr. Justice Green's judgment. But can I just take you through its components? The first is the affidavit from Mr. Page, which is in the supplementary bundle at tab 40. And in that affidavit, January 2022, he recounts the evidence that he gave at trial about innocent discovery. He sets out details of the investigation work which he managed and performed for RAKIA, and explained that monthly reports were made to RAKIA from February 2015 to May 2020, and that, as he recalls at the time, I think he says he didn't have access to them, as he recalls, they plainly included hacked material, and he deals with their delivery to Mr Buchanan and to Mr Gerrard and to monthly briefings on them to the ruler. And he gives evidence of meetings in Cyprus and London at which the innocent discovery, false, perjurious explanation for obtaining the hacked material was conceived and confected. Mr Gerrard and Mr Buchanan being party to those, and then taken further at the Hotel Musig by Mr Gerrard, where he sought to teach Mr Page and Halabi how to do that and subject them to mock cross-examination. The perjury school. There's a curiosity about that, which is that Dechert's case was, there was an attempt to say, well, that would have been privileged. RAKIA's case is that the perjury school, the Museg meeting, this is only applicable to the Museg meeting, was actually conducted without its instructions. And in consequence, whatever material is available in regard to that will no doubt have to be revealed by disclosure, not being protected by privilege. Quite a striking difference. Then there was, second, a similar affidavit from Mr Halabi. He was not the investigator, but he was the person who was said to have made the discovery of the BitTorrents on the internet and gave an entirely false version at the trial. Third, there is Mr Page's invoices for the work. Can I show you one of them? Supplementary bundle tab 36. What happened during, after trial, after these proceedings had been launched, the main hacking proceedings had been launched, and in the course of one of the interlocutory hearings before Justice Green last year in March or thereabouts, the point was raised as to, well, it's obvious that Mr Page did do some work that has emerged from the trial. Where are the invoices? And having taken an instruction over the lunch adjournment, Mr. Tomlinson returned to tell Justice Green that they've been searched for, there are no invoices. That was RAKIA's case, right up until the disclosure phase in the hacking counterclaim remission. And thereafter, a little bit later last year, the invoices emerged from Mr. Page. It's not on the screen. Oh, no, it is. I'm sorry, it should now come onto your screen. It was on my one screen, but not the other.
Yeah.
I can't quite explain that. This is one of the invoices. And there are a whole range of them. These were monthly reports. But they all take essentially the same form. So you get Mr. Page's company invoicing the RAK, the Ras Al Khaimah Investment Authority, that's RAKIA, Ras Al Khaimah. Description. 2, conducting feasibility study to identify market potential to provide management services in the African subcontinent, establishing free zones. Phase 1, 2.4 million dirhams. And so they go on, running it at whatever it is, $200,000 or $300,000 a month. And before RAKIA's departure, and at the last hearing attended by him, Mr. Tomlinson very candidly accepted that, well, these are obviously rubbish. And there really is no explanation from RAKIA about its failure to disclose these documents and its participation in having the investigative work disguised as feasibility studies for free zones in Africa. That's the third. Then, of course, you get the project updates reports themselves, said to have been destroyed, which then emerged in June last year, totaling over 1,000 pages, including 20 reports which were placed before His Lordship Mr. Justice Green in the permission hearing, and some extracts of which have been included in your bundles, and I'm going to take you to some of them. So I'll come back to that. Fifthly, notes of interviews conducted with RAKIA's erstwhile General Counsel, Mr. Al-Sadek, who is in prison in RAKIA, in Iraq, I beg your pardon, but which were disclosed in other proceedings, the proceedings relating to his torture.
Who was that?
His name is Karam, K-A-R-A-M, Al-Sadek, S-A-D-E-Q. He was the general...
Karam Al-Sadek, yes.
That's right. He was the general counsel of RAKIA at the time of the hotel transaction. He subsequently fell out of favour and has, for some considerable time, languished in a jail in RAKIA. He was interviewed on a number of occasions by Mr. Gerrard. Indeed, that was the subject of Mr. Gerrard's belated corrective witness statement after the trial, having to accept that actually he had interviewed him on a whole number of occasions without appropriate equivalent to the Police and Criminal Evidence Act protections, without his lawyers being present, and so on. All of that dealt with in Deputy Judge Lennon's addendum to his judgment. But in the Al-Sadek proceedings, the interview notes have now been disclosed by Dechert, and both those notes and the emails between Mr. Gerrard and Mr. Buchanan reveal that in the course of those interviews, Mr. Al-Sadek has said that Mr. Azima had introduced the buyers of the hotel. Incidentally, Mr. Gerrard and Dechert maintain in their defence in that claim that the evidence given by them, I beg your pardon, by Mr. Al-Sadek to them was true, and that seems to include this evidence. So those are the 5 categories. Now it is appropriate to elaborate a little bit on the effect of that material on the analysis of abusive process. I want to make 5 points before I turn to the project updates themselves. The first point. As to Mr. Page and Halabi, their affidavits provide compelling evidence not just that the innocent discovery explanation was contrived and false and dishonest, but that it was a contrived and dishonest case manufactured and presented to the court at the initiative of RAKIA and Mr Buchannan and Mr Gerrard, and under the guidance and tuition of Mr Gerrard, including at the perjury school. That's the first point. The second point is that Mr Page's evidence provides compelling evidence contrary to the case presented at trial by RAKIA, Mr Buchannan, Mr Gerrard, and the ruler, that RAKIA had in fact procured unlawful hacking, and it had investigated both Dr. Massad and Mr. Azima, and the reports of that investigation were regularly made to those individuals, and the contents of those reports would include obviously unlawfully accessed material. Thirdly, RAKIA suppressed disclosure of the invoices, and that must be the disguise of the invoices must be something to which the ruler and Mr Buchannan, certainly Mr Buchannan, who was the person running RAKIA under power of attorney, must have been party to that dishonesty. And if I was to sweep the update reports together, without going to the detail, although I am going to do so, they inescapably show an extensive unlawful investigation of Mr Azima, an express project, I'm going to show you these words in a moment, of finding the means to take Mr Azima out of play in regard to their dispute with Dr. Massad. That's what they were attempting to do. The reporting of private and personal information which cannot but have been unlawfully obtained, described by the investigators as gathering intelligence as ammunition. Fourthly, a whole range of material in the report supporting Mr Azima's case in regard to the claims RAKIA made against him, not only on the question of reliance, which it does go to, but also to other elements of the claims, and I'll show you. And they show that RAKIA has withheld disclosure, dishonestly withheld disclosure, on important contested issues, including in regard to its claims. And they show unlawful access to Mr Azima's privileged communications during the negotiation of the settlement agreement. My own friend Mr Macefield rather skated over that when dealing with that point. I'll again show it to you. It really is extraordinary. They're busy negotiating a settlement agreement on the heavy lift claim with Mr Azima, and at the same time they are reading the advice being given to him by Miller and Chevalier in the United States. So we say, really, when you sweep it together, there is now a case as to intentional, deliberate, pervasive dishonesty, the construction of a false case, which is of an entirely different kind and degree than that which was before the Court of Appeal before. I should say, it would be entirely wrong to assume that the evidence that the project update reports were all destroyed pursuant to an innocent security protocol is not something which should be taken as read. The dishonesty is so pervasive, and that excuse has not been raised in regard to the invoices, that the only conclusion one can safely draw is that the disclosure process was dishonest and wholly inadequate for the trial. Now, as to materiality, I'm going to go through it in a little bit more detail a little bit later, but can I ask you to have particular regard to the case on materiality that is pleaded. It's a case that was analysed by His Lordship Mr Justice Green, but the re-amended counterclaim is in core bundle tab 18. I'm not going to drag through each of these. What one finds, if you have regard to those passages, the set-aside claim sets out in great detail both the new evidence and why it is material. And could I ask you to have particular regard to the following paragraphs: 187, 200, 206, 219 to 222, 230, 254 to 5, separately 256 to 7, and then 260, in which the materiality points are pleaded out. The reason for the little short and the jumps between is, of course, in each case, new evidence identified, explain why it is material to each cause of action. And the judge worked through all of those points in finding that there was a real prospect of success on materiality, and the learned friend Mr Macefield did not attempt to work through those points. I want to take some examples of the project update reports. I'm happy to continue or take the break now in the view of the 4 o'clock stop.
Took a break now.
Yes. Okay.
How are you doing?
Reasonably well. I won't finish today, but I am doing reasonably well.
But I just, so the parties know, I did, having said earlier, maybe we sit at 10 tomorrow, in fact, I had forgotten I've got a meeting, so I can't sit at 10, but if absolutely necessary, we'll sit beyond lunch, but we won't sit beyond 3 o'clock.
I'm great.
Okay. Call rise.
Yeah. I didn't blame you. Because I think one of the three apologised, and the one who's supposed to 3 in the afternoon.
Yeah, it's always worse. It sort of builds up.
But the important thing is when it's cold. Sometimes it's too cold or it's too hot. It can never be.
I think it's this amount of hot air.
Yeah, and I'm sure that you think that. I'm sure that you think that.
There's an absence. So much more blend. At the same time. At the same time.
Because I just think I like to show my South African colleagues, ex-South African. So this is 27 screens.
What is it like that's in Germany?
Obviously, COVID brought in remote hearings, which they had to try, which they generated in
You've
British
got a
manual.
beautiful modern court, I know actually. So,
Oh yeah. No, the court buildings are okay. But I mean, if you go to the Court of Appeal, as I was doing, they would still, they'd lay out all the judgments in your skeleton. They'd put the books up.
I'm old enough to remember them doing that, but
In fact, one of the things is they put the little slip as a page for each side. One of my senior colleagues was very concerned that some wouldn't have an advantage, but that's the other side. So you go and change that. No, it is not as electrically sophisticated as this. And they get instant. You only get the transcripts, you get it the next day. There's none of this live note stuff. Nothing of the sophistication of the Magnum system.
no, we got into it quite quickly. So I'm also
For them to get. Well, it's a lot of infrastructure, of course, and having Magnum for these cases is expensive.
Yes.
I recently, in arbitration, used Epic trying to come in. They don't understand. It's not yet a good system. So if you are asked, would you like Magnum again? My advice to you is, notwithstanding that it's about 5 times the price, Magnum please. Well, I like to do that too. And you know, I have the extra screen so that I can see my marker, which makes a big difference. But it's the way of the future.
Yeah, now's your chance. You want to broadcast.
In this case, sounds like it's Oh, no, actually, I think we should. We did say decisive. And it's there's a power. Correct.
Thank you. So I'm about to turn to the project updates. I can't resist a side note. My learned friend Mr. Pilbara accused us of misquoting Takar. We hadn't actually. We quoted it correctly in paragraph 34 of our skeleton and then later paraphrased it.
Right, okay.
But I don't think that's the biggest point in the case.
No, that's just a sort of side swipe.
So I'm not going to show you all of the project update reports, and what you have in the bundle is only extracts from them, so you get page 1 and then page 8 and so on. There are thousands of pages of these things, but I do want to show some of them to you. Can I ask you to turn to tab 24? Oh, there's a supplementary bundle, tab 24. This is, so 4th of August 2015, a year before innocent discovery on the internet, as it was said. Executive summary. Project Beach report, Farhad Azima, which is quite a bad start for Rakia's case that he didn't investigate Mr Azima. Executive summary. Based on the mutual decision with the client, the following document presents a full intelligence report on Farhad Azima, hereafter FA or the generator, who seems to be one of the closest and most influential partners of KM, that's Dr. Massad. And then explains, the main effort is placed in order to assist the client, that is Rakia, in taking the generator out of the dispute between Dr. Massad and the client. To do so, one of the main objectives is to find potential criminal activity in order to present it to US law enforcement authorities, etc., and then seeks to identify things of that kind. So the purpose is, so we are investigating Mr. Azima. The reason we're doing so is to kick him off the field of play in regard to Dr. Massad, and we're going to do that by seeking to find, by illicit means, things that can generate complaints that can be made against him. And then if you turn over the page, there starts from page 2, his background and personal information.
Yeah.
Starting with some relatively anodyne things, background, his date of birth, you have his passport number and his social security number, and details of his family, and then you start to get into his assets and estimates of their value. Copy of his passport. Over the page, page 4, personal financial information, picture of a house, assets in multiple jurisdictions. It's not on the screen again. I'm sorry. Page 4, please, to the operator. Mills, are you in the hard copies or are you looking on screen?
I'm looking at the hard copy, so I'm blessed with the actual page.
as well as what's on screen. So
I've got it on my screen.
there's obviously a
You have it on your screen.
Well, my own screen, not your office screen.
Oh, listen.
we're all there one way or another.
If you're there one way or another, I'll continue. I'm not quite sure what's happening, but but you then start to get into details. Just a curiosity, page 5. A condominium, this condo unit, number 404 of Trunk Tower 3, is a most treasured luxury residence. The monthly mortgage payment is $2,923.29 US dollars, down to the cent. And as you then page through, you then get the assets, page 5, page 6, page 7, with minute balances, down to the cent, with account numbers, with all of the investments and their value. Going over the page 8 and 9, with the companies in which he holds shares. Page 10, page 11, diagrams to show his and his wife's investments, their securities, and their total value down to the nearest $1,000. His participation, all of the companies in which he participates, page 11. And then goes on to try and generate some, I shouldn't use the word generate, to try and identify conduct of his that there might be a complaint about. So that's what they do. Can we go all the way down, please, to page 36? Perhaps page 32 first. You start to get individual 30, 31, 32, 33, individual emails between people being produced. Page 33, Mr. Farhad's, Azima's email to J. Solomon and Karam al-Sadiq. The idea that you could read this and not think that this material is being illicitly obtained is completely absurd. And indeed, it deals with the hotel owning company, page 19. The formation. You recall that a complaint pursued even in the address of Mr. Macefield, either this morning or yesterday, was this undisclosed interest of 10% in the company which was formed in order to buy the hotel. So here you have it. Formation of Eurasia Hotel Holdings Limited. Dr. Massad, 5%, Mr. Azima, 10%. The three Iranians, Mr. Hosseinpour, Mr. Fasudeh, and Mr. Nayebi, 25, 30, and 30%, total 100%. So, known from the beginning of August 2015 that is what had happened. But of course, Mr. Buchanan said, no, they never knew any of this. And it ends, page 36, with a desire for more investigation. So, summary and recommendation. We believe this evidence and information shows exposure to several potential criminal activities. If that can be made public, it can force him to invest both energy and funds in defending himself and slowly to fade away from Dr. Massad's battle against the client. So to be taken off the battlefield. And then various details. Down the bottom of the page, in order to make the approach to the US authorities more efficient, we suggest carrying out an in-depth investigation in order to understand the full scope of Mr. Azima's business ventures and contacts to the Iranians and other shady characters and entities. And then on page 37, it's important to mention the risk which the client is under due to his past relations with Mr. Azima. And maybe Mr. Azima will seek to jeopardize him and then his financial status and so on. So there you see the bare truth of what had really been going on. Can we then pick up the next tab, 25? So, Magnum Operator, please, supplementary bundle tab 25, page 1. This is 2 weeks later. Executive summary. Based on JB instructions, that's Mr. Buchanan. Based on Mr. Buchanan's instructions, we've crafted an updated report dedicated to SIH, that's Star Industrial Holdings, recent financial misconduct. That's a company owned by Dr. Massad. It is also the company, the strapline of which, Star Industrial Holdings, was used in the phishing emails that were placed before the Court of Appeal. Obviously, we didn't know that at the time of the trial. But you can see they were investigating Star Industrial Holdings. Moreover, we've discovered sensitive documents intentionally concealed by Mr. Azima from Mr. Buchanan in relation to the RAK heavy lift matter. You see that then in paragraph 6. We've discovered confidential information, including memo, balance sheet, and FA's supporting documents, and an allegation that they were probably intentionally not shared with Mr. Buchanan. And then some other background on the heavy lift venture. You then see that in the pages that follow. Page 9. You get documents regarding the heavy lift deal. And again, email. So email from, like you say, it's from, sent to Afzadeh, copied to Mr. Azima. Here is a memo and supporting documents on the claim. Oh, it's from Mr. Adams, from Ray. This is for your eyes only. The documents are confidential unless Mr. Azima specifically authorizes you to give them to someone, or unless RAKIA employs hackers to get them off your computers. And then various things said about the training academy. Now, Mr. Macefield said of this, well, these documents weren't of any particular use to RAKIA. So in other words, it did do hacking, it got some documents, but it wasn't very happy with the yield. And what that fails to take account of is that Mr. Buchanan's evidence to the court was that they had no information about Heavy Lift's claim at all. And that is patently false. And I'd refer you in that regard to paragraph 224C of the re-amended counterclaim. That's Core Bundle tab 18, page 76. And of course, emails then follow. Dr. Massad and Mr. Azima Third one, a week later, tab 26. An intelligence report, mostly on Dr. Massad. The main effort is placed in order to assist the client to achieve his goals in relation to his dispute with Dr. Massad. So we've got the most up-to-date documents and data. And then main findings, then set out, some of them are redacted. But over the page, page 2, according to a contract signed between Mr. Azima and RAKIA, Mr. Azima had to provide RAKIA with all relevant information which relates to the Sheraton Tbilisi hotel transaction, and to act in good faith and with the utmost professional integrity and in the best interests of RAKIA. And H, we've managed to get to obtain the signed memorandum between Mr. Azima's partner Ray Adams and Dr. Massad regarding the RAK Training Academy, which is what lies behind the heavy lift claim, dated 11th of April 2007. So again, heavy lift material, and as to the hotel, the so-called sham referral agreement, already obtained as at the 24th of August 2015, and it is then referred to in a whole range of the reports that follow, this one and those that follow, and nary a suggestion will you find that that agreement has been identified by the client as being one that it did not conclude. The idea that this is not material evidence, which ought to have been before the court when it considered the issue of whether the referral agreement was a sham.
Is that the contract that's referred to at page, if you turn over the page to the next page, it's actually page 8 of the report, but
It
FA
is.
RAK contract regarding Sheraton Tbilisi.
That's right.
Commission and Services Agreement signed between RAKIA and FA.
That's right. And it's then described as being in footnote, Appendix 6.
Yeah.
Appendix 6 is not in the extract that you have. If you wish to see the agreement, but it is the agreement.
But is it signed by RAKIA?
No, it's signed by Mr. Azima.
No, but it's between FA and RAKIA.
Yes, it is.
Well,
Yes, exactly. I'm sorry, maybe I didn't make myself clear. The parties are them and Mr. Azima, but it's
yes,
only signed in the copy that they have by Mr. Azima.
right. But I mean, your point is that if these are reports going to the ruler or to Mr. Buchanan, and this was in fact a sham agreement which was never made, it's to say the least rather surprising that somebody didn't pick up on this.
Exactly. Exactly. I mean, it is simply extraordinary, and it features in these reports. Again, the very agreement has been put before them. Could I ask the operator please to bring up October hearing bundle tab 93 and page. And can we go please to page 90, we think? There it is. Is it on your screen? So there's the Master Referral Commission and Service Agreement,
Yeah.
dated 25 October 2011, setting out the entitlement to the 5%, so much criticised, and providing for expenses. In fact, it has 2.1 and then 2.3, providing for expenses. And if we page down, and then down again, you'll see at the end, signed by Mr. Azima, not signed by RAKIA, it is true. But immediately you would have expected an inquiry to have gone up if there was any suggestion this wasn't genuine. So the inference to be drawn from the fact that RAKIA had it all this time is necessarily that RAKIA believed that Mr. Azima did have an entitlement to commission. And of course, his case was, in the trial, that the ruler had approved his commission. And the ruler didn't come to give evidence. And in the end, the ruler said he didn't know anything about it, and Deputy Judge Lennon accepted critical evidence. Can we go to we'll skip a couple and let's go to tab 29, rolling a few months forward. You'll see it's Project Beach Report 13 January 2016. That should not be misunderstood as the date 13 January. It is the 13th report in January 2016, and you can see at the bottom it's dated the 4th of January 2016. Just turning down, you can see page 5, which is the second page. So page 2 of the bundle, page 5 of the report, there's an investigation regarding the Sheraton Tbilisi deal. A couple of weeks ago, while Mr Azima was in the mediation process with the client and Dr Massad, his partner Afsana Azadeh has sent him questions and answers that should be answered. So they're gathering information about the underlying deal. And then that continues over the page, then various other things, and then page 9 of the report, which is at bundle page 6, the privileged documents. So there you get, we have uncovered Mr Azima's actions after Mr Buchanan presented him with the settlement agreement in the heavy lift dispute. Immediately after receiving the agreement, he sent it to his partner, Mr Adams, and his trusted lawyer, Mr KB. And the biggest concern is the settlement and warranty clause. And according to Mr Bear, whose opinion is much appreciated, all correspondence with Mr Buchanan should be stopped immediately. That should obviously be correspondence CE, not TS. Should be stopped immediately until Mr Azima will discuss the settlement agreement with KB. KB advises Mr Azima not to look too eager to sign it and not to pose his concerns yet. KB believes the agreement seems like a trap. He has warned Mr Azima that the formulation of the agreement, mainly the part below, which is the good faith warranty, is not only vague language, but it covers both the past and the future. Now, and then going on to the reaction to the settlement agreement and so on. I Mr Macy will just skate it over there. I mean, this is truly extraordinary. In the underlying dispute, which gives rise to the settlement agreement, which gives rise to RAKIA's claims against Mr Azima, RAKIA had live access to Mr Azima's legal advice. It really is quite unprecedented. Page 15, which is bundle page 7, I beg your pardon, bundle page 7, internal page 15. Based on Mr Bear's reaction and Mr Azima's statement that both sides, the lawyers, will complete negotiation for the agreement, we will update on due course, should obviously be in due course, we will update in due course regarding the inner discussion in the FA's team. So we're going to get more of this stuff, and we'll report back to you on what we find and how they discuss it and what conclusions they reach. Now the updates, say this to you. I'll show this in a later report. This was discussed at trial. The updates on the inner discussions in Mr Azima's team included an update that Mr Azima and Mr Adams and another employee had a bet internally as to the amount that RAKIA would ultimately offer to settle the heavy lift claim. And at the first trial, RAKIA's pleaded case was the fact that they were making bets about what the outcome would be was supportive of the argument that the claim was exaggerated. It's a bit of a stretch, but that was the case being advanced. So what you see is RAKIA obtained through hacking the very documents and uncovering some of the things that before the deputy judge were said to show that the investment representation was false and obviously affects reliance and so on. The point is they knew all about it. Tab 30. Later in January, now the 26th of January, a comprehensive action plan we found it convenient to assemble a comprehensive action plan that will lend extra weight to the client while further weakening Dr. Massad's stance at court. And we're going to suggest various things: intelligence gathering, public relations, litigation support, direct influence activities, and actions with US government law enforcement authorities, which they then proceed to set out in what follows. So page 2, who are the targets of the action plan? Best of my knowledge, the persons in the picture is Dr. Massad on the right and Mr. Azima on the left. Now one can see the rings have been drawn around them on the firing range. And what they're then going to do is various things, including intelligence gathering. So during the last year, page 3, we have been supplying the client with intelligence ammunition against Dr. Massad and other relevant players, such as Mr. Azima, together with tailor-made reports and comprehensive analysis. We suggest to concentrate our intelligence efforts on specific tasks to be prioritized by the client. So the investigators are saying, listen, tell us what you really need, and they then suggest various things that they might do. Page 4, amongst those things, further investigation, this is the last paragraph, to uncover misconducts and involvements of players such as Mr. Azima. So they still want to continue to target him. Page 6, media strategies, including PR and media tools to be used against Mr. Azima. There is no evidence, so somewhat disappointingly, Mr. Azima is not in fact being operated by the US intelligence agencies, but then we suggest various things we might do whether to change that or anything else. Page 8, litigation support. We've got various indications which we suggest can be pursued, some for Dr. Massad, and then for Mr. Azima, we suggest we aim in on all of these things that may reveal wrongdoing. And over the page, page 9, top of the page, we believe that establishing a designated task force that will include, in addition to our team, a representative from the client's legal firm for the purpose of mapping and fully understanding the legal needs, which will enable us to tune in with the requirements of the legal team in order to provide a solid legal case against Dr. Massad. But you can see what they're trying to do. Direct influence. All about Mr. Azima and his involvement with somebody called Hussein Mahalati in selling aircraft parts for Iran, and things that might be established. Reading down, we'll be able to understand more about Mr. Azima's deals to Iran and his connection to the Iranian regime. He said he is in the Rafsanjani political camp, and will be able to influence Mr. Azima to the client's benefit. It can also give us as well the opportunity to build a honeypot for Mr. Azima if decided. I'm not exactly sure what they had in mind, but you can well see the intent. And then paragraph 5, involvement of US authorities. In order to eliminate Mr. Azima's activity regarding the client, we suggest various things, trying to accuse him of sanctions busting and the like. So directly targeting Mr. Azima. Can we then go to the next one, which is tab 31, the same day, but this is now the Beach report as opposed to the action plan. That's also 26th of January 2016. Latest findings. It aims to provide additional information to the latest report that was prepared by the client's law firm. We have exerted our best efforts in order to deliver answers to queries raised by the legal team, such as Eurasia Aviation Holdings, a company in which Mr. Azima had an interest, Dana Jets, etc. Moreover, in the light of the potential upcoming meeting between Mr Azima, Dr Massad and Mr Buchanan, we have supplied additional findings regarding Mr Azima's links to Iranian entities and to Karam al-Sadek. So here, there's Mr Buchanan coming in. There's a meeting coming up, and he's going to be provided with intelligence on Mr Azima for purposes of that meeting. Main findings below, you can see deals with Eurasia Aviation Holdings, in which Mr Azima had held 10%, and then deals with paragraph 5, with Mr Azima having sold some of his shares in Heavy Lift International Airlines. More detail on Eurasia Aviation Holdings over the page. And so it goes on. Tab 32. 3 weeks later, or 4 weeks later, 22nd of February 2016. Again, as always, executive summary explaining what we're going to tell you about. Towards the end of that paragraph, we've been able to uncover evidence of funds from the Sheraton Tbilisi's account that were used by RAKIA Georgia, that was the owner of the hotel, to cover financial shortfall in its annual balance. And regarding Mr Azima, we've been able to discover the financial structure of his recent venture, Global Defence Systems. Paragraph 6, you can see the financial details relating to the operation in 2011 of the Sheraton Tbilisi account. And again, going down to page 15, it's page 4 of the bundle. Back to the privileged communications. Our US source, that is of course a self-evident euphemism, has confirmed that Mr Azima's lawyer, Kirby Bear, is still reviewing the suggested settlement agreement drafted by the client's legal team, and the main issue is clause 3.2. And our source will continue his efforts in order to uncover the final version. And last one, tab 34, skipping one, page 1. Recent intelligence findings regarding various individuals, including Mr Azima. Following the meeting with the client's legal team, we have been able to provide additional information about Dr Massad and about the link to Mr Azima as to activities in Congo. And we can report that Mr Azima is currently dealing with issues arising from the Panama Papers. And then they set out the detail in all of that. You can see, for example, paragraph 6, we've obtained an apology letter from the Democratic National Committee to Mr Azima for rejecting a donation offered by him earlier due to media reports at the time. Quite an extraordinary thing to have found. And he's considering hiring public affairs representative. He's worrying over the page about his public profile. And paragraph 10, according to our source, he received the settlement agreement with joy. Settlement payment, I beg your pardon, with joy. And he informed Mr Adams and Mr Baird, stated that both of them had lost the bet. So presumably he bet high and they bet low. And that being, those bets being featuring in the first trial itself. It really does paint the most pernicious picture of RAKIA's conduct and Mr Buchanan's conduct, and of course we can't say what representatives of what client's legal team there were meetings with and who attended those meetings. But what we do know is that Mr Gerrard agreed that many of these reports were submitted to him, and Mr Page's affidavit also says that. So his profession to be ignorant of unlawful activity simply lacks any credibility at all. And I've already referred you to the schedule to the re-amended counterclaim, tab 18, page 92 of the call bundle, which then lists their evidence and identifies dishonest evidence that they gave. Now, can we go back to the judgment? Core bundle, tab 10, page 33, paragraph 132. I told you that's where the judge deals with learned friend Mr. White's attack in the commission hearing on the materiality, the satisfaction of the materiality condition, and I've shown you that he ultimately concludes that it is satisfied easily. Paragraph 135 over the page. There had been reference to an earlier decision of Mr. Stephen Gastovich, QC, referring to the melting pot of the evidence. And Mr. White criticised that notion and said, well, you've got to be much more stringent than that in order to satisfy the high hurdle identified by Mr. Justice Birss in Choddy and Stein. And then a qualification about that, and then the judge says he would respectfully endorse Lord Mr. Justice Leach's dicta in Tinkler. That's Tinkler versus Essen. I think that the bundle includes another Tinkler case, which is Tinkler versus Ferguson. This one is not in the bundle. Tinkler versus Essen. There will be cases in which the new evidence is so fundamental to the credibility of the witness that it will be material, even though it is not directly relevant to the substantive issues. And then some examples. For example, a solicitor gives evidence. She is a solicitor and holds a valid practicing certificate, but does not say she's been struck off for mortgage fraud. The evidence of striking off will be material. Two witnesses conspire together to mislead the court. I would consider evidence of the conspiracy to be material. Now, that's not this case, because the evidence in this case does go to the issues on RAKIA's claims themselves. But the point that is being made is, even if it was only credibility to which it was directed, it's a question of degree, and the evidence may be so fundamental to the credibility of the witness that it will be material pervasively. And that is, that attribute is true of this case. Mr. Buchanan's credibility, Mr. Gerrard's credibility, and the ruler's credibility. At a minimum, there may also be others. And then in paragraph 138 to 141, the judge summarised a number of reasons why the new evidence was plainly material, not only in that fundamental credibility sense, but directly as to the substance of RAKIA's allegations against Mr. Azima the allegations against Mr. Azima themselves. And he deals with paragraph 138, the good faith representation over the page, 139, the heavy lift representation, that's what the investment representation is, and quoting my submissions over the page. Continues 140, then 141, as to the unlawful conspiracy claim, and then paragraph 142. It is difficult to see how it could be argued that Mr. Azima has no real prospect of satisfying the materiality condition, assuming that he can prove the pervasive fraud on the court that he alleges. It would be open to the additional defendants to challenge the materiality of the new evidence at trial, which of course they will seek to do.
Sorry, which paragraph you on?
I'm sorry, paragraph 142.
Yeah.
At this stage, the question is whether his case on materiality is fanciful, could not succeed, whether he has no reasonable prospect of success, no real prospect of success. And the judge says, well, it's very difficult to see how you could ever say that. But of course, that Mr. White had, that notwithstanding, tried quite hard to do so. in particular by reference to the assumptions made in the Court of Appeal in paragraph 40 of the Court of Appeal judgment. And he said various things, and the judge reasons through all of those, and then paragraph 147 says the threshold is plainly met. Now, I do want to deal with the materiality argument itself on the facts in a little bit more detail, but I'm not going to do that today because it's pointless starting it, because that you'll need to hear as a whole. So what I'd like to do is turn to the Court of Appeal judgment in the last time that we have available this afternoon. So I'm just going to make a note to myself. So turning to the Court of Appeal judgment, which is in supplementary bundle tab 11. My own friend Mr Masefield worked through the Court of Appeal judgment, and indeed the judgment of Deputy Judge Mann, and read you very large parts of it. Yeah. And I'm not going to do that. I also can't speak as fast as he can. So I want to stand back and consider its structure and its objective meaning. I did say I would eventually get there to what is the core question in this case. It is important to understand the grounds. Now, you've been taken to them. They're in tab 5 of the supplementary bundle, and there's no dispute about it. So what you have is grounds 1 to 4 and 6, which concern hacking, and that includes new evidence as to hacking, which is ground 6A and 6B. And then you have ground 5, which is the contention on appeal that applying the jurisprudence which is identified in Summers and Fairclough Holmes and in Jones and Warwick by the Supreme Court and the Court of Appeal respectively, what the court should have done, so the argument went, was to strike out RAKIA's claims as an abusive process, that's Summers and Fairclough, or exclude all of the evidence, that's Jones and Warwick. So in the grounds, it's not an attack which directly seeks the setting aside of the judgment for fraud or applies that jurisprudence. It relates to Mr Azima's pleaded defences as to strikeout and exclusion of evidence. Then grounds 7 and 8 were two quite limited points in regard to RAKIA's claims. In the one case relating to the investment representation, the heavy lift representation, that's ground 7, and in the other to the conspiracy claim, that's ground 8. And the initial points that were taken, and I'll come to the expansion in argument, but the initial points that were taken was, in the case of the heavy lift misrepresentation, the only evidence was of Mr Buchanan's reliance, and there was no evidence of the ruler's reliance, but the cross-examination had shown that the decision had to be taken by the ruler and by the ruler alone. The Court of Appeal, of course, eventually rejects that argument for various reasons, including the Zurich decision, but fundamentally accepting the probability that Mr Buchanan's recommendation must have acted on the ruler's mind in some way, and that was enough. And then ground 8 was the point that the conspiracy relating to the sham referral agreement had not been put to Mr Adams. And so it was said, case like that, it's a case of dishonesty, you've got to put it to the witness, you've got to give him an opportunity to deal. And ultimately that's rejected on the grounds that, well, it was put to Mr Azima, and modern litigation, witness statements, you do get notice of points, all of those sorts of arguments, and so it was not a good enough reason to go behind that. But that was all. That was as far as the grounds went, because of the Fage and Chabadi limitation. And then there was ground 8A, which is Mr Nayebi's witness statement, and ground 9, which is the alternative claim relating to non-disclosure of the fact that RAKIA had known for a year that Mr Azima had a 10% interest in the hotel company. Sorry, I put that pejoratively. Non-disclosure of his interest, which we now know they had known. Yeah. Now, Mr. Macefield took you exhaustively.
But if we just looked at grounds 7, 8 and 9,
Yes.
you would say in the light of what's now apparent from the project reports which you now have, that those grounds would have been a good deal wider than they were. And there would have been a wholesale attack on Mr Buchanan's reliance.
Absolutely.
Together with a wholesale attack on the suggestion there'd been a conspiracy.
Yes, absolutely.
In the sense that the referral agreement was a sham, because they'd known about it since 2015, but never said,
Exactly so.
we never entered that agreement.
Yes, indeed. Yes, indeed. Exactly so. And there you get in paragraph 71 of the Court of Appeal judgment the proposition that Mr Buchanan's reliance effectively hasn't been challenged on appeal at all.
Yeah.
Well, you can, as the Chancellor says, well imagine what we might have said had we had this evidence. Now, Mr Macefield took you then to Mr Lord's submissions and indeed to Mr Tomlinson's response to those submissions, and you've been given some additional references in that regard by both Mr Pilbara and Mr White. With respect, it is either not the point or it is of very limited relevance to the point, because the question is not what was argued. The question, when we're trying to decide what the Court of Appeal did, the question is what the Court of Appeal did. And the evidence of that proposition, described by the Chancellor yesterday as a factual question, I suppose to some extent it's a legal question, factual question. What does the judgment mean? The primary evidence for what the judgment means is the judgment. And it, of course, doesn't have a subjective meaning, it has an objective meaning. You've got to read the judgment, work out what it says. Should immediately say, I accept that my leader in that appeal, Mr Lord, King's Counsel, put the case as high as he could. Of course he did. And they've shown you all of those passages. But none of that changes what the grounds were, and none of that changes what the Court of Appeal did. And when one reads the Court of Appeal's decision, my Lord the Chancellor said that earlier today that you didn't see why the judge found the judgment confusing, that reading it seemed relatively straightforward. Now, of course, I don't know what was behind that point, but I would say, indeed, if one reads it, what you see is a structured working through of the issues. And issues that are dealt with under issue A belong under issue A, and issues that are dealt with under issue B belong under issue B. And I see the time, so I will work through the paragraphs, the structural points I want to make about that at the outset tomorrow morning.
Very good. We'll say 10:30 tomorrow then, please.
All right.
We're all planning lunch today. I'm not sure we're going to get it. I don't know. What I do know is that if I finish at 12:15, the prospects of you three confining yourselves to 45 minutes are utterly nonsense. You won't rise with that.
No. Did you find anything?
You made some fairly outrageous submissions this afternoon, Thomas, but that's the most outrageous.
You do a sufficiently good job, Thomas. We won't have anything to say.
Yeah.
Would you mind if we didn't, I don't know if we told them it's 4 o'clock, but a check may come.
That's a good point.
If I can get a number.
No, just phone.
Thank you very much.
Everything back.
The lecture, just the box, the lecture.
5099.
Yes, we're 10:30 tomorrow.
Definitely.
Thanks, Richard.
No problem.
Yeah. That should be the junior clerk, I think. Okay.
Have you told the junior I'm finishing at 4? Maybe not. I certainly haven't. Maybe Arishi did. But you seem to do an excellent job of keeping an eye on everything, Fred. Thank you very much. This back, what I'm thinking of it.
Once people, always people.
It's got to be some upside of getting old, eh?
Where are the buttons of your trousers rolled?
How do you cope with that? All the like flicking the pages?
Oh, I know.
So boring.
Yeah, I know.
Sister wasn't behaving today.
Yeah, I know. I noticed that. Were you freezing as well?
Yeah, I was stuck on one page for a long time.
I love it when they're like, I don't know what's happening. Well, obviously there's technical fault. Why is it? Yeah. Funny. Oh, God. Literally can't wait to get home. Sorry, am I allowed to leave my shoes here tonight? I'm back tomorrow.
Yeah, you can leave your stuff. It's fine.
Oh, okay, thank you.
It's gonna be locked.
Oh, perfect.
I'll certainly do my stuff.
closed down now. It's showing the email on screen.
Mine is.
Oh yeah, let's go.
Okay. God, thanks. Is it showing anything now?
No, it's just on the home screen now.
It's just what?
It's just on the home screen
Oh.
now, but it was showing on your email.
No. Saying going home now. Bye. Yeah. But hopefully it won't be too late tomorrow. Although we say this, it does feel like it's probably going to be a full
So
day.
we'll be finished by lunchtime.
No, yeah.
I ain't gonna have
Bye.
Bye.
That's the worst thing, when they make you think you're doing it when you finish, and it doesn't happen.
Yeah, it
It
does.
feels every minute feels like an hour.
Especially if you're not interested. Like it's not your
Too true.
job.
I'm not interested at all. Okay. The building before we finished yesterday, so that's good. Alright, see you in the morning.
later are you going to lock up?
I can wait 10 to 5 minutes. Is it gonna take long?
I don't know where my junior clerks are to get my files. I just want my files. Right, I'll take them outside. I think we had forgotten to tell them that we were stopping at 4 rather than 4:30. Oh, that's not going to work. Hang on.
I just need to replace one of the documents in the folder.
Yes.
Yeah. This is 417, right?
Yeah.
Is this the only folder there is? It looks like it. It was. Maybe not. Apologize. I think I've opened it by force. It's okay, so that's fine. Okay, no, it's not just me. Alright, thank you. Just had to do that. Okay? Thank you.
he was. Oh, I'm pretty sure this is
Yeah,
him.
Yeah.
Okay, brilliant. Thanks very much.
Cheers,
Thank
Fred.
you.
Yeah.
Are we taking?
Yeah, Rishi, Alex.
That's all right.
You take Craig's again.
Yeah. No, I left that one. It's a couple of talking. No, I think I need those. I think I need another bag.
Oh yeah.
I think I need to bit of a day. Honestly,
Honestly.
a weekend break is what I need.
Say that about her, like stuff,
Yeah.
and she started taking a bit of the detail. Yeah, like they're seriously. They're
I
good
think
for
there's
you.
something to as well. I never something sounds so stupid. And those some bits aren't written in deep.
They are, aren't they?
It's something like that. They give you something, right? Although not to speak out. I haven't had sunday in like 2 months.
Yeah.
And then I had sunday. I'm like I feel like I'm trying. Yeah. I think I don't actually know what's taking me. I hardly hear. I'm getting it in the movements. How was that? It's like, yeah. It's a very basic guy. This morning, listen, he's so money. He's like, Dad, you fucking getting me tapping. You have energy. I was like, alright.
I don't think it works in one day.
No. No, exactly. So I take them when I'm feeling a bit jaded, get on over, and then
Yeah,
so
man.
he's like, so yeah. Oh, he said about getting, he told me. He was like, apparently every day.
No, I've been telling you guys, I've been speaking to you guys so many times. I already done my degree and everything. I don't need any help. Thank you.
But I said that I don't really want to have.
Yeah,
So that's it. I'm like, I want to get this thing over with.